The broadcast is now starting. All attendees are in listen-only mode.
Okay, welcome everyone to the November 2018 webinar. This month we are going to talk about firing people, disciplining as well, but we're going to eventually talk about disciplining and getting all the way to firing on this presentation. This month I am your speaker. My name is Kevin Mosher. I'm certified labor and employment law specialist, managing partner for Thompson Co. up in the Minnesota office. And I am very excited to present this topic to you. I think this is my favorite topic in all of HR. So, when you're a kid and you dream of like what you want to do with life, and you think like, you want to be a police officer or firefighter, I guess. I don't think I ever dreamt of being somebody that would advise on firing people all the time, but this has grown to be my favorite topic. It's pretty exciting. So I'm really happy to share it with you. And this, if you are new to the webinar series, welcome. This, if you need HRCI or SHRM credits, they've been approved, or CLEs for various states, they've been approved. If you did not check the box when you registered for the webinar, then just shoot us an email and we'll get you the certification that you might need. This is a closed webinar. It is being recorded, so those of you who want to watch it afterward and continue to enjoy the information that's going to be presented here, you're welcome to do so on our website, www.thehrgenius.com. Also, I'm not opening it up. Like I said, it was closed. So if you do have any questions, you are welcome to ask them on your right side. There should be a prompt with questions, and you can type them in, and I will try to get to them through the presentation. I can't get to all of them, and in which case I will circle back over to you and try to respond to your question if I don't get to it during the presentation. If you raise your hand, it's not going to do me any good. Because I would actually need to see the question itself. So you're welcome to type something in there. Okay. Like I said, very excited about talking about this presentation. We have a lot of material, but I'm pretty sure we're going to be able to get through it. Okay, so we are going to talk about discipline. We're going to talk about the different types of discipline, the different categories of discipline, and then we're going to talk about a general process for going through discipline and getting all the way to termination. I know, like me, most of you went into HR with the idea that you would get to break hearts and make people feel bad and discipline them and fire them. And I know that. I mean, I know that's why most of us went into this profession. But sometimes we that's not always appropriate, which is silly. But for the most part, we need to understand that there is a process in place that people probably should get some sort of process and an ability to explain themselves and to try to rehabilitate themselves if it's performance related performance related issues or misconduct. So we'll talk about that, and we'll talk about doing investigations and what we have to watch out for in troublesome situations if somebody is in a protected class or engaging in some sort of protected activity. When I say protected, I mean protected by state or federal law. Either because of their race or age or religion or national origin or disability, that sort of thing. Okay, and then we'll talk about some very brief post-termination issues as well. All right, so when I talk about discipline, we break it down into three categories. There really is a fourth, but we're not going to talk about the fourth, which is reduction in force. And really, attendance is just a subset of misconduct. Okay, so why do we discipline employees besides just because we enjoy it? We don't want to, we discipline employees because of one of these three reasons. Fire them because of reduction of force. So 1, because of their attendance, 2, because of misconduct, 3, because of performance. Now, attendance and misconduct are kind of part of the same genre. Misconduct really means a violation of a policy or a rule, maybe even a law. But let's just, for sake of for a business, we're talking about a violation of a rule. So if I say that, if I ask you, well, why are you disciplining or terminating somebody? And the answer is, well, they violated a rule. The rule might be an attendance rule, an attendance policy. It might be, some sort of insubordination. It might be a harassment policy. But we're talking about rules, guidelines that have been set in, that are expectations of conduct in the workplace. You expect people to not steal. You expect people to show up on time. You expect people to call in when they're going to miss work. You expect people to not harass other coworkers. These are all types of misconduct. When we talk about performance, we talk about the person's actual performance of their job duties. That's totally different than misconduct. Now, clearly, attendance might feed into somebody's inability to do their job well. So, these are not entirely separate boxes. But performance, generally, when we talk about performance, is we're talking about somebody who's having a difficult time performing their duties. They're not meeting your expectations for their work product itself. And when we talk about discipline and we talk about eventual termination, that it's performance where we want to really have a lot of documentation. A lot of times you hear the whole document. That's true with regard to performance. It's not so true when it comes down to misconduct or even attendance. And the reason is because you've already documented it with a handbook or with policies or with just general rules of what an expectation of conduct in the workplace. I always say this, and so, sorry, I'm repeating myself, but I always say that you do not have to have a policy that specifically says don't stab your supervisor. That you just don't have to have it. It kind of goes without saying that you shouldn't take a knife and stab your supervisor. You don't have to have a policy against it. You don't have to have a policy against everything in the workplace. That's straight up misconduct. Don't have to have a policy against it. So do you have to have a lot of documentation in advance of firing somebody for stabbing their supervisor? Absolutely not. You can just, go ahead and fire them for stabbing their supervisor. It goes without saying that was prohibited behavior. Performance is different. Performance, we want to make the person understand as much as you can. And I know it's really, really difficult to get through to people because everybody thinks they're awesome. But with performance, we need to apprise the person and to make it clear to them that what they're doing is not meeting the expectations for them in their job. Okay, let's look at these with a little bit more detail. So again, attendance is a subset of misconduct. One thing, and so it's, it goes without saying, like the whole stabbing a supervisor example, it goes without saying that people should be showing up to their jobs. However, it's still really good and advisable to have a policy laying out attendance. For example, not all companies have some sort of no-call, no-show policy. For example, typical in the workplace is 2 days or 3 day no-call, no-show. But a lot of companies don't have that explicitly laid out. But then when it gets to the point where the person has just not shown up for work for the last 2 days and you want to fire them, it becomes a little bit problematic when you don't have a specific policy in place saying that the person will be terminated after 2 days of no call, no show. It doesn't mean you can't fire them. It just becomes a little bit more problematic if you suddenly adopt without any advance notice of a no call, no show. If you don't have an attendance policy at all, then the person could argue to you that you should have warned them that failure to show up for work a couple days in a row would result in their termination. Now, am I worried about a lawsuit for you if you fire somebody after 2 days of no call, no show? Not so much, but it does set you up. If you have that policy on a no call, no show, it puts you in a really good position to win on unemployment. You're going to have a really difficult time. Unemployment's such a crapshoot anyway, but you're going to have a very difficult time winning unemployment for somebody who, for example, doesn't show up for 2 days in a row, if you don't have a specific policy in place notifying them that if they don't show up for work 2 days in a row that they're going to be fired. Like I say, not too worried about a lawsuit, assuming that you are uniform in your application of a 2-day no-call, no-show. But if you haven't notified the person, you're probably not going to win unemployment. If you try to, claim that the person knew that they intentionally didn't show up and that they knew that their behavior would result in their termination. The other thing with attendance is that there are areas where their attendance it cannot be counted against them. So any sort of attendance policy, we want to make sure that the employee's absences are not protected by state or federal law. So if their absences because of work comp situation, or FMLA, or maybe the two of them combined, or some sort of potential disability where we know about the disability and the person might need time off as a result as part of an accommodation, we want to make sure that we don't count that against somebody under an attendance policy. And there are a lot of different types of attendance policies. Some companies just don't have them at all. Some will do points where if they're tardy, meaning tardy, if you're not familiar, meaning that you're late for work, or even that you leave early without authorization from work. Yeah, that could be a tardiness. That might be like 1 point under a system versus an unexcused absence, which might be 3 points. And then after, 9 or 10 points, that might result in termination. And along the way, you should probably have some sort of write-up. And so that's a typical type of attendance policy, but there are a lot of different flavors that this could take on. But the point is that if you're going to discipline people for attendance, you should have a written policy on this, putting the person on notice, your employees on notice, that their behavior could result in discipline up to including termination, depending on the number of violations and how your attendance policy reads. Misconduct, again, misconduct being the general overall form, but we do break down misconduct we can break down misconduct when we're talking about discipline into different categories. So subcategories of misconduct would be gross misconduct, serious misconduct, and then minor offenses. So gross misconduct, for example, might be, like the picture indicates, might be some sort of sexual harassment. Right? So you've got a policy. Let's just assume that you have a policy on sexual harassment. If you don't have a policy prohibiting sexual harassment, you need to have a policy prohibiting sexual harassment in the workplace, as well as prohibiting discrimination in the workplace. That should be in your handbook. Let's assume that you have that policy, because you should. If you lay out in the policy that the person should not harass, touch, fondle coworkers, that sort of thing, then that's likely to be gross misconduct that after you have an investigation into it could result in immediate termination. Under the same policy, you might find that somebody, like in this situation, you just see the hand on the shoulder, inappropriate, yes, perhaps not. Just hand on the shoulder, if it's just a one-off event, probably not the type of thing that results in automatic termination for somebody. If there are a number of these incidents with shoulder touching, add the circumstances to the situation that you want. But if there's a number of them, then yeah, a number of serious offenses might lead up to termination. But in and of itself, hand on the shoulder, probably not in and of itself gross misconduct. Touching, kissing, yes, gross misconduct. Probably call for immediate termination. Should call for immediate termination. But just hand on shoulder, probably more of a minor offense or a serious offense. Swearing at a coworker might be a minor offense, depending on the workplace. If you're in a warehouse, it's probably not that big of a deal. It might be a minor offense that you want to put a stop to it. Swearing at a supervisor, however, probably more of a serious offense. If the person's been warned of it in the past, and depending on what the profanity is, if it's also insubordination, that might be even gross misconduct that results in immediate termination. So we want to identify the types of levels of misconduct when we're looking at the behavior that the employee is engaging in. And when we are doing our investigation, we're taking down the information. We're trying to figure out how to discipline or counsel the employee. Understanding what they did and then categorizing it is important for us. And then also from an HR perspective, this is where HR becomes very critical and important, is understanding how the company or organization has handled these sorts of things in the past. So if you fired somebody for just a one-off touching of a coworker, like in this picture right here, where the hand is on the shoulder, in a lot of situations, a lot of companies aren't going to fire somebody for just doing that, alone. But if your company has fired people in the past for putting a hand on the shoulder, and then they don't for somebody else down the future, well, then that's a problem, and that's a potential disparate treatment for that person, because one person was fired over it. And if we're just talking about being fired over this same exact situation, that sort of disparate treatment could lead to a potential lawsuit over, discrimination, depending on the, whether somebody's in a protected class or not. So as you can imagine, gross misconduct would result almost always in termination on the first offense. Like I say, if you've got a handbook, you've probably got a code of conduct of some sort in there. You certainly should have a non-discrimination, anti-harassment policy. That's one type of code of conduct. You also might have just a policy itself that just says code of conduct, and you list all the things, no theft in the workplace, no physical violence, no physical behavior in the workplace, and you just, name it, name the type of things that you might have in there for code of conduct. You might even have a dress code policy that you could put in there. So if you have that sort of policy in your handbook, or just even separate from a handbook, just a straight up policy, and somebody violates it, you might just want to go and fire that person over that first offense if it is gross misconduct. And here's a typical list. Again, it could be more than just this, but there's a typical type of list of what gross misconduct often is. And every industry is going to be different. Horseplay in a warehouse, industrial facility isn't going to be as big of a deal as horseplay in an accounting firm or in a law firm, right? Like, it would be super weird for people to start engaging in horseplay, I think, in an office environment versus, not to say that it's acceptable, but it's probably not necessarily gross misconduct in all industrial type of facilities versus in a professional setting. Possession of weapons, illegal substances in the workplace. These are all gross misconduct that are likely covered already as being part of the code of conduct expectations that you have in your handbook and under your policies, right? You probably have a drug-free workplace policy. If you find that somebody's got drugs on them in the workplace, you don't need to give them a warning about this. You've already warned them through your handbook. That's why we have everybody sign off on the handbooks, so that not because we like their signatures and to see their dates and see how they sign their name. It's to make it clear that they have received notice of all of these rules that we have. So if you want to go and fire somebody for violating your drug-free workplace policy, there it is. Illegal substance on them, gross misconduct, fire them on the first offense. A serious offense would be something just underneath that. It would be disorderly. So whereas horseplay in a law firm might be gross misconduct, first offense, you're out of here, horseplay in a warehouse setting might be more of a serious offense. You might not be able to recruit anybody if you fired people for horseplay or profanity in the workplace. It might be a real problem for you. So that might be more of a serious offense. Doesn't mean that you shouldn't counsel somebody on it and that you shouldn't give them a warning that their continued behavior would be a problem. But it doesn't mean that you're going to automatically terminate. Same thing with a harassment investigation. If you find that the person, touched on the shoulder, obviously warning not to do it again. Maybe you have some other consequences like a suspension or some sort of training that the person needs to go through. There might be some other steps, but something short of gross misconduct. And then a minor offense would be even below that, where we would warn the person that continued behavior is a violation of your policy, profane language, rudeness, horseplay, gossiping in the workplace, that sort of, maybe smoking in a non-designated area. That might be more of a minor offense that you probably don't necessarily fire somebody over on the first situation. And so, like I say, we have to understand, we have to understand our history, we have to understand our workplace, and we have to understand how we have looked at all these sorts of behaviors that employees engage in the past, so that we can categorize them to figure out like what we need to do as a response. Is it going to be just a counseling? Is it going to be a suspension? Is it going to be immediate termination, or some combination of those? Performance, so that's gross misconduct. And again, that's going to be off of a written rule or expectation, right? Performance is different. Performance is much more challenging. And so when you hear about document, what you're really talking about is performance. Now, obviously, we are going to document when it's like a minor offense on misconduct and a serious offense, short of termination on misconduct. But performance is the big one where we really need to make it clear to the employee. If we want to lower our risk and try to avoid a lawsuit, we need to make it clear to the employee that their continued performance of their job in whatever poor manner or not meeting the expectations for the supervisor, for the company, that continued performance and way that they're doing their job could result in discipline and termination of their employment if they don't get better. So we want to definitely document all of that. Now, along the way, there might be reasons why the employee is performing poorly, and then you get into a disability situation, and maybe they're having difficulties with coworkers. Maybe there's harassment going on that you didn't know of. But that's why we want to document on performance, so that we give the employee, one, the ability to rehabilitate themselves, because I know, like I say, I know we all like to fire people. Like, I know when I wake up in the morning, I'm like, oh, I hope I get to fire people today. But sometimes we do need to try to rehabilitate and offer the opportunity to rehabilitate. And some employees take us up on it and some don't. But we want to, in many, many situations, allow them, when it's a performance-related problem, we want to allow them the opportunity to try to fix the behavior so that they can be, an upstanding member of the company or organization. And we want to do that through documentation, through counseling of them, so that we can get to the point where they're like a really good employee. Okay, so if we are going to, so that's performance. So performance, we want to definitely document. We want to have a framework for going forward where we apprise the person that they're continued, where we put them on notice. And that's where and we'll talk about last chance agreements and written warnings here in a second. But that's where we get into this whole framework for performance, where we want to definitely make it very clear what the employee is doing, and then what the expectations are, and then how they need to fix it going forward. So what the employee has been doing, what the expectations are, and what they need to do to fix it going forward. And then finally, consequences of failing to fix it. It's that simple. Written warnings, that all of your written warnings, there they are. Those four parts. That's basically it. What they did, what you expect, how they fix it, and steps that you're going to do on your end too to help them fix it. Might be one-on-ones, might be counseling, added training, that sort of thing. And then finally, consequences of failure. All your written warnings, that's your outline for them. Okay, so disciplinary notice, here it is. So breaking that down from those four things, I think I've broken it on 3 on this slide. But on these 4 things, so here's how you do it. So you've got those. That's your written warning, and we'll talk about last chance agreements with more specificity coming up. But here it is with the disciplinary warning. State what the employee did that they shouldn't have done, right? So here's what you did. You punched your we're going to talk about performance, right? You failed to finish the TPS reports. The TPS report project. Like, everything comes back to Office Space, right? If you are in HR and you haven't watched Office Space, by the way, this weekend, or maybe over the Thanksgiving holiday, like maybe that's it'd be a good use of an hour and a half or 2 hours of your time. So anyway, so you're going to state you failed to get the TPS reports done as directed. If you need to give sufficient detail on what the TPS reports are specifically, I asked you last Friday to come in over the weekend to finish up the TPS reports so that they could be filed on Monday. You failed to do that. We want to use objective language, right? I don't want to throw in there, you scumbag, if you failed to do the TPS reports, like the lazy SOB that you are, right? Like, we don't want to do that. That's not, you were probably off at church instead of coming in to do the, right? So this is problematic if we start to add colorful language into it, right? So we want to add objective language. Here's what it is. I told you on Friday, come in and do the TPS reports. They need to be filed. They need to be filed on Monday. You failed to come in over the weekend. They weren't prepared to be filed on Monday. Therefore, you failed to fulfill this stated request, right? This project. If there's a rule or a policy, that would be more of a misconduct thing. Then that would be it. If you would put that in there, this is a performance, so we're not going to talk about a rule. If there is a situation where the person's failed to do the TPS reports previously, we would throw that into this to just bring in more of a history to it, right? So on Friday, I told you to come in over the weekend and to do the TPS reports so that they could be filed on Monday. We have had this same problem in that 2 months ago, I asked you to also do the TPS reports on Tuesday, to be filed on Thursday, and you failed to get them timely done on that time as well. This is an ongoing problem. Done, right? We're not going to talk about any colorful stuff, and we're not going to call names. State the expectation. Next paragraph. I expect that when I give you a directive on TPS reports or anything, that you follow through and complete the job, right? So there it is. That's my expectation, that you follow the rules. In addition to so I jumped to the consequence. What you could also throw in here is what I'm going to do to help you out. And in some situations, there's something to do. In some situations, there's maybe not anything to do. In this situation, you could say something like, you're going to, as a result of this, you're going to need to go to in-house training on TPS report filing and do 2 hours of training so that you understand how to do TPS reports. Okay, right? So that would be like going forward. Consequence, failure to do any more TPS reports in the future timely will result in the termination of your employment, right? So this is, and that's okay. We've jumped to this being the second situation, right? Because the person previously failed to do it like 2 months ago. We've referenced it. We've talked about the current failure to do it. So we're going to jump to consequence. At this point, it's a serious offense. And we are going to say that the next time, so third times you're out, 3 strikes you're out. So the third time you're going to be fired. We wouldn't describe the consequences if you're firing the person right now, right? Like if you're firing the person right now, you don't need to do all this. But if this is like the final written warning or just a written warning that you're giving to the person, this is how you lay it out. Why is it important to document? Okay, so what we have here is with regard to performance, we want to make sure that we have documented everything, and the reason is so that we can prepare, so that we can best protect ourselves and lower our risk for a potential lawsuit, right? So why is it important to document? So with misconduct, it's not as important because we've documented it, hopefully through a policy or a rule or just an obvious expectation that you don't stab your supervisor, right? But with performance, we definitely want to document so that we can show that we've given the person the opportunity, because juries love to see that people have had an opportunity to fix their behavior, right? Because everybody has it's so subjective. Like whether or not you're doing a job well is super subjective. So most people think they're awesome. And so the whole idea with documentation is to correct them of that belief if they are not awesome. And a lot of employees are not awesome. In fact, it tends to be the employees who think that they're really awesome tend to oftentimes not be super awesome at their jobs, at least. So we want to definitely document, because at the end of the day, The key is that if we do fire somebody or discipline somebody, that we have done it for legitimate reasons that have nothing to do with potential discrimination. So this is the whole lowering of our risk. So we want to make sure that we've documented the process that we've given to people, because like I say, judges and juries love to see that people have been given a chance. If you're, can you fire somebody who's disabled, or somebody who's just come off FMLA, or somebody who just got pregnant? Absolutely. You can absolutely discipline or fire somebody, but you better have documentation showing that you've given them a chance to fix it, and that you're being objective here, and that you're not discriminating against them because of their FMLA or pregnancy or disability. So we want to have documentation definitely showing that we have a process in place, and that we have given them the opportunity to fix the behavior. And then also for these other reasons, like you might not remember, people can bring a lawsuit under federal law up to 300 days after, they can go to the EOC up to 300 days after they get fired or some sort of other adverse employment action. In many states, it's up to a year. And then the trial might not be for 2 years thereafter. So, I mean, that's very common. So you could be talking about like 2 or 3 years between events, and just trying to remember, like, oh, did I counsel the person on this day? I mean, trying to remember 3 years later when you're testifying, very, very difficult. And so you want to have a contemporaneous documentation showing that discipline occurred. One of the reasons that, I mean, and here's the thing: if you get a request for a personnel file from a former employee, a lot of states allow for this, that you're required to provide a copy of the personnel file to former employees. And so why do they ask that? Well, they ask that because they got a lawyer, and that lawyer's trying to think about whether or not it's worth their time to even threaten a lawsuit. And if the employee says, "Hey, I was fired," and the plaintiff's lawyer that they're talking to is saying, "Well, why were you fired?" And the employee's like, "I don't know. I was awesome. Like I was really awesome at all times." And the plaintiff's lawyer is like, "Okay, that sounds," and so then you were fired, right? Like that doesn't make any sense. Well, then they ask for, the first thing they do to see if it's worth their time is they want to see the personnel file to see what sort of discipline occurred. And if the employee who's telling their potential lawyer that they're awesome, if the employee, if there's nothing in that employee file talking about discipline or a record of them being a problematic employee or difficult or anything, if there's no record in there, the attorney is going to say, "Whoa, okay, great. This might be a good one. I've got an employee who says they were awesome. They also happen to be disabled or older or whatever it is, pregnant. And I'm looking at the employee file and there's nothing in here about it. So great. That gives that attorney right there a whole lot of extra optimism that they're going to have a good lawsuit against you. So one of the reasons that we do document all this stuff, there's memory and factual events, and it's really good evidence, and shows non-discrimination, hopefully, if it's well documented. But one of the other reasons is because we want to be able to beat back these plaintiffs' lawyers from being excited about suing on behalf of their clients and suing you. So anyway, really good risk management. And thank you, by the way, to the person who commented on Bling. That was a really good. That's really funny. Again, Office Space. We're just going to talk Office Space. We'll do, maybe in 2019, although I think we've already kind of set on a schedule for the webinars in 2019. I think maybe we should just do like an homage to Office Space. Okay, investigation flow. So you've got a complaint of some sort of conduct, right? And so how are we going to investigate? It might be harassment. It might be a bad practice, some sort of, bad thing that the employee has done. So we're just going to flow through a typical investigation. I've done entire webinars on this investigation flow, particularly with regard to Me Too and harassment investigations. And if you want to watch those investigations, they're great because, of course, I'm awesome and like everybody is. So you are welcome to do so on the HRgenius website. They are on there, and you can enjoy. Okay, so first thing we're going to do, somebody comes to you and they have an allegation, right? And so what are we going to do? We are going to look into their story. It might be a supervisor saying that the subordinate employee has been doing some sort of bad behavior. It might be a coworker saying that so-and-so has harassed them, whatever it is. We're going to assess the allegations to determine initially how much, what type of, effort and how we're going to further investigate it. If the initial allegation is my lunch bags are missing from the refrigerator, I think it's because I'm pregnant. Like, this is you're probably not going to go into some sort of like crazy investigation and get legal counsel involved, right? It'd kind of be a waste of resources. But but you should still look into it if the person thinks it's because they're pregnant, for sure. But if the allegation is, hey, I'm, being fondled by my supervisor, and the supervisor, whatever, touched me, kissed me, whatever, that's a bigger deal, right? And we're going to put a lot more resources and jump on that one right away, maybe even suspend the supervisor to might take some serious actions right away. So we want to assess the allegations. We want to get an overall understanding of timing on this. Do we have to potentially suspend somebody? What type of resources do we need to bring legal resources into it? Is it over a missed lunch bag in the break room, or is this something pretty serious like harassment or physical violence, that sort of thing? Is it going to be, in another way to put it does this look at the initial outset like it's going to be gross misconduct? Does it look like it's going to be serious misconduct, or is it, at the worst case, it's going to be some sort of minor counseling, right? Like, you find out, you do your Magna Carta of investigations here, and you find out that the person is taking the lunch bags out of the refrigerator, right? Like, oh no, like, you're probably not going to fire that person over it unless they've got a history of it, or doing other bad things, but you're going to maybe counsel them, right? Like a minor conduct type thing. Okay. So then we're going to gather facts. So we want to make sure we get the initial story. We identify the people. We start interviewing people. Anybody, did other people witness? Anybody witness the taking the lunch bag, the groping of the coworker? Anybody witness that? We're going to just let those facts guide us, right? Sometimes we might need two people in, one person to ask questions, one person to take notes. Especially if it's of a more serious matter, like a physical violence, a harassment type of thing. You're probably not going to throw a lot of resources at a missing lunch bag, but you are going to throw a lot of resources at an executive groping a subordinate, right? And then we just might have to go back and follow up with some of those witnesses if we get more, newer information. We want to take notes along the way, if possible. And again, it doesn't have to be a huge thing if it's just a missing lunch bag, but it does need to be a big thing if it's a potential serious offense or gross misconduct. Like I said, we're doing the interviews. We want to avoid gossip. We want to, as much as we can, we want to avoid empathizing with the people we're interviewing, or even the people that are making the complaint. For some of us, that's easier than others to not empathize with them. But for the most part, we want to stay as neutral as possible. If you're compromised as an HR person or as a manager, then you might need to bring out somebody outside in, whether it's an attorney or some sort of like workplace consultant, HR consultant. You could bring them in to do more of a neutral investigation, because at the end of the day, you want it to be, if it's potentially serious or gross misconduct situation, you want the investigation to be as objective as possible. You've got everything. You understand as much as you can the situation. You've got all the facts. You've determined who all the players are in the brown bag, missing lunch bag situation, and then at that point, you then might have to make a judgment call, right? The person probably didn't admit to taking the lunch bag from the refrigerator, but if if you, based on everything that you've determined from your investigation, if you think that the person did, there you go. You get to play judge and jury on this. And as long as you've come to it objectively and you're not just picking on the person because of their race or religion or whatever, but it's an objective decision, then you get to make that call. It's pretty exciting and empowering. You get to make that call, even if it's he said, she said, and you get to go one way or the other. And if you want to find against the person, well, taking a brown, lunch from somebody might be minor offense. If it happened like 10 times or 5 times or whatever, it might be more of a serious offense. And so then you look at that. And again, that's misconduct, right? It doesn't have to do with performance. You look at that, you make the determination. Is it going to be a minor offense? Is it going to be a serious offense? And then you determine what your discipline is going to be. We're making the call. It's he said, she said, but I've made the call. This person, let's call the person Brian, took the lunch bag 4 times out of the refrigerator. I'm going to suspend Brian for 2 days. That's my call on this. We're going to suspend Brian for 2 days without pay. Not going to let him use PTO. It's going to go straight up without pay. And then the counseling is going to be written up, and it's going to go in Brian's personnel file. There it is. Misconduct. We've determined it's serious misconduct, and it's going to go in the personnel file. If Brian's got a history, I look in the personnel file and I see that Brian has a history of other types of maybe minor misconduct, or maybe even a combination of performance issues plus misconduct. And I just say, like, this is the tip of the iceberg, and maybe some previous warnings were in there saying you could be terminated for continued behavior. Then maybe this one, in combination with everything else, in and of itself, probably not going to fire Brian over taking the lunch bag a few times or 4 times in my scenario. But in this situation, because Brian maybe has a history of some other minor things, none of which altogether led up to his termination, but maybe this is just the end of it, I decide to fire him. So it might not be gross misconduct, but I look at the history and I determine that no, this is all of it together is enough to fire him, and I just decide to fire Brian on it. It's totally fine how you want to come to it, as long as it's legitimate and doesn't have anything to do with some sort of protected activity or class that Brian has. Because if it is a protected activity, then it's going to be riskier. So when I say protected activity, I mentioned this earlier, we are looking at things that are protected under state or federal law. So we're talking about here are the different laws. I know you all know them and know the codes of them and everything like that. Title VII is like the race discrimination and religious discrimination, that sort of thing. There's also age discrimination, which is separate. NLRA is union activity, so affiliation with unions or engaging in concerted activity. FLSA is Fair Labor Standards Act. That's the wage law. So if somebody's complaining about not being paid minimum wage, or somebody is saying that they complained about not being paid overtime, it's potentially illegal to retaliate against them, discipline them for that. So we want to see, so one of the problems is that if somebody is complaining, or so say in my situation with the brown bag, if I make a decision that, and I don't have anything in the personnel file for this Brian character, and I don't have anything in the personnel file saying that he's been doing some bad things in the past, and if I then jump, he took the brown bag, I'm just making a he said, she said call on it, and I immediately jump to termination. And if I know, or if I know that Brian recently filed a work comp claim, if Brian potentially is depressed, has some sort of disability, if Brian recently came off of FMLA, or told me he's going to need FMLA in a few weeks, these are potentially problematic. And so I better be really clear and really good on my documentation, because if he can show that the reason that I jumped to termination over just taking a brown bag out of the refrigerator in the break room, that I immediately jumped to termination, that's going to seem to be pretty draconian. So can I, as an employer, it's at will? Yeah, absolutely. I can fire anybody for anything, right? As long as it's not an illegal reason, protected by these laws here, these, FMLA and Title VII and all that. But yeah, I could fire somebody for any reason, whatsoever. I don't like the way that they hold the phone when they're on it in the office, right? I don't like the fact that they're football fans of a certain team. I don't like that, the way they type on a keyboard. I think it's just super annoying. They pound the keys too, gives me a headache. Like, I could fire them for any of these reasons. But I can't if it's over some sort of protected activity. And so if Brian has, or if I do, I can't because of that, because of the protected activity. But if Brian has been engaging in protected activity, like being on FMLA, he might be disabled, well, then that's going to make it really problematic. And I better be really clear on how I came to the decision and how the decision was actually objective, because otherwise it's going to be a risky termination. So I want to make sure. Now, is it going to be a risky termination if the situation is entirely different? So in the situation with the brown paper bag, if it's just a one-off, I determined that Brian stole a brown paper bag out of the refrigerator of a coworker. Could I fire him for it? Yes. Should I fire him for it? I don't know. If Brian just recently filed a work comp claim, it's going to be a risky termination. Doesn't mean you shouldn't do it, but it's going to be a risky termination. Is it going to be a risky termination? And the reason is because taking a brown paper bag 4 times out of the break room, that's different than stealing from the company. That's stealing from a coworker. I think it's different. You might disagree, but I think a jury would see that differently. I think a jury would say that's pretty draconian to jump from 0 to 4 bags missing to termination. I think they would see that difficult, and they would read in between the lines and say, no, you're probably really firing Brian because he just recently filed a work comp claim. Would it be a risky termination if the situation were different and Brian recently filed a work comp claim and then the next day stabbed his supervisor? Absolutely not. Go and fire Brian. Like, a jury is not going to, I can't imagine a jury finding that Brian retaliated. But again, we have to look at the circumstances of all in the entire situation here. So risky termination where Brian stabs a supervisor, no, that's called an intervening event. Not too worried about it. Risky termination if we are just, making an objective call and we're just firing him over taking the 4 bags from a coworker. I think that's going to be difficult where he's been engaging in protected activity. If we can show that there's been some sort of counseling along the way, that there's some other stuff that goes into it, I think we can justify the termination better. But we just have to understand that we can't always, that we're taking a greater risk if we don't have either a clear policy or a clear communication, or if we don't have a clear history of taking this same exact sort of action against employees, so that we can't say that, no, we always have fired Brian for employees in the past for taking lunch bags out of the refrigerator. We have been telling Brian along the way not to do this sort of thing. This type of documentation is going to help us. This type of history is going to help us. If somebody has been engaging in protected, even if somebody is in a protected class or protected activities, we can, just because somebody is in a protected class or engaging in protected activities, that does not give them carte blanche. It does not make them Teflon from discipline or termination. We can absolutely discipline and terminate people. We just can't do it because of those reasons. And so we have to show through the documentation and through the way that we're processing this, that we are making this for legitimate reasons that are objective and that anybody would make the same reason, and has nothing to do with the protected activity, has nothing to do with the protected conduct. So here's, how to handle all these tips for that. Okay. So here's the road to litigation. There are a number of situations which would make it a higher risk. Let's just call it termination. Could be just a discipline, but let's just call it termination. One where it's performance-based, a performance-based termination, and you have not communicated to the person that their performance could lead to termination. Because remember, we always come from the perspective, everybody thinks they're awesome, right? If I haven't told so-and-so that failure to do the TPS reports by Monday will lead to termination, it's a pretty risky termination. Does it mean you can't terminate somebody? Absolutely not. You go ahead and terminate. Go ahead and terminate for typing loudly on the keyboard or wearing a football jersey to work that the supervisor doesn't like. Can you do it? Absolutely. Is it a risky termination? Yes, it's going to be a risky termination, especially where somebody's in a protected class or engaged in protected conduct. So we have a lack of communication. We have a lack of documentation. We haven't shown the person, we haven't demonstrated the person through communication, through documentation, that their behavior, that the way that they're performing the job would result in the termination of their employment. So that's going to be a riskier termination where we haven't given them warnings. We haven't done the documentation. Also, the other situation where we see a lot of lawsuits is where the person has a new supervisor. So often where a new supervisor comes in, and a lot of times new supervisors come in for a very good reason. And the reason is because the previous supervisor was not very good. It's not always the situation, but it's often the situation. And so a lot of times the previous supervisor was not really good. And so then we have a new supervisor come in, and the new supervisor comes in and says, I'm going to be really good and I'm going to start setting the rules. And, the old rules are out and the new rules are in, and the employees who are skating by under the old system, who are loving the fact that they weren't being held accountable for their performance, those employees suddenly don't like the new sheriff in town. And those employees then start to think, oh, maybe it's because I'm older. Maybe it's because I'm disabled. Maybe it's because I'm a female. Maybe it's because I'm whatever. And they start to, in their minds, affiliate the reason that the new supervisor is, they might think, singling them out is because of one of these, some sort of protected status that they're in. And the supervisor probably isn't thinking that at all, maybe, but probably not. They're not probably trying to single out people, but instead they're just wanting to come in and clean up the place. And so a lot of times cleaning up the place means trying to hold people accountable, and then those people don't let themselves be held accountable, and then eventually they get fired. We definitely want to have a good communication and good communication with these employees, telling them about how things have changed and how they need to get on board with the new order, and that's critical for their and because these are the expectations now going forward. Old expectations are out, new expectations are in, and then we let the employee come to hopefully, improve to meet the new expectations. But especially with a new supervisor situation, we have to have a lot of documentation when it comes down to performance related issues. So that's one of the areas where we often see a lot of termination. A lot of lawsuits. And I always tell employers, how do you, can you stop an employee or a former employee from suing you? And the answer is no. There's nothing you can do. The only way you can do it is by giving them some money in a severance agreement, and by enticing them with a big enough carrot with the severance agreement to sign off on their rights to sue you. But otherwise, you can't stop there's no way to stop it. The only thing we can do is by having good processes in place that lower our risk of a lawsuit. And if you've got a good process in place and the plaintiff's lawyer is looking at, and they're looking at the personnel file and they're saying, no, looks like there was a lot of communication along the way. Looks like maybe this new client of mine who just got fired, who's telling me that they were awesome and they were never told like how they aren't awesome. That lawyer is then looking at that saying, no, I'm not entirely trusting of my client. It looks like the company probably had a good process and gave them a chance, and that employee didn't take it. So that's what we want to do to lower the risk of a lawsuit, but there's nothing we can do to stop it. And so, it's just through serendipity that you as an employer have never been sued, but really you help yourself by having good HR processes. Last chance agreements. Last chance agreements are kind of like final written warnings. They're basically the same. At the end is basically telling the employer, and we've already gone through the parts here, but again, the final consequence is this is your last warning. There's the door. If you continue to perform poorly, if you do any more TPS reports, failure to follow my orders on TPS reports, or if you continue to swear at your supervisor, or if you continue to engage in horseplay in the office, you are going to be fired. That is anything else, you're done. And so here are the parts of a last chance agreement. The only difference between a last chance agreement and a final written warning or I'm sorry, and a general warning is that you might not say next offense equals termination. So you can kind of like take out part 5, talk about other consequences, being short of termination or up to and including termination. But in a last chance agreement, you make it very clear, like, you are done. The other thing that otherwise I think I kind of already talked through these other issues. The only other thing that I would mention is that you obtain the signature from the employee, not to have the employee buy into this, though I think it's important for the employee, if they want to continue to working, that they do buy into this. But you obtain the signature. The signature is there to say, I acknowledge that I received it. Just like with the handbook, they acknowledge that they received it. Employees don't, employees don't have to completely drink the Kool-Aid that you are. But again, at the end of the day, you get to make the determination. You get to set the rules. If the employee, so you need to get the signature from the employee saying that they've received it. That's the key. If they refuse to sign it, that's an indication they're probably not going to be around too much longer. But if they refuse to sign it, I would not fire them over that. I would just put on there, refuse to sign on this date, and then put a copy of it in their personnel file, give them a copy with that whole thing that says the employee refused to sign, and then treat it as though it exists, right? So completely go forward with the last chance agreement as though they, did agree to it, and even whether they signed it or not. As opposed to the next on the termination letter, here's what we do and we don't want to do. We want to keep the termination letter short and simple. You do not need to talk the employee into agreeing with you. The great part about being in management or in HR is that you really don't care if you don't need to care if the employee agrees with you or not. Just like with the last chance agreement, they're signing off that they received it. Same with the handbook. They're signing off that they received it because I get to set the rules. It's amazing. Like, you're in charge. So you get to set the rules. They don't have to drink the Kool-Aid with you. With a termination letter, keep it entirely professional. Don't empathize. Don't sympathize. Same with a termination meeting. Don't empathize with them. Just the facts. Set out that you're, that they're gone. You've set out that prior discipline. You've set out that they violated that they violated this policy for misconduct, or that was a combination of misconduct and performance related issues. Confirm their last day of employment, and then put it in the personnel file, and then mail it to them. If somebody quits, or if they just stop showing up for work, I always kick out a letter. I always want to kick out a letter to them confirming that they've voluntarily quit their job. They just stop showing up. You assume that they've quit. Don't just let it go without being said. Send them a letter confirming that they voluntarily quit their job on such and such date. Put it in the personnel file and mail it to their home address. If the employee tries to apply for unemployment benefits, then you've got that letter to remind yourself that no, they walked off the job. So here's an example of a termination letter, which, since my son plays like Fortnite nonstop, could, maybe someday when he gets in the office environment, I'll probably be him, right? So short and simple. We're not going to argue. We're not going to be argumentative at all with the person. We're just going to we're going to state the exact facts. Gamer Boy, as you're aware, we have both verbally and in writing counseled you regarding playing video games on your phone during working time in violation of our performance and conduct expectations. Boom. We're talking about performance because it's taken away from the way he's doing his job. And we're talking about misconduct because we have an expectation that he's actually working. Could also be considered wage theft, right? Because he's getting paid for the time that he's not working. Technically wage theft, maybe even and then insubordination, because he has been warned about this in the past, right? This is fun. We can just like keep adding bad things to the list. So we've got insubordination, we've got wage theft, we've got it taken away from performance. We wrap in that we've talked to you before about it, verbally and in writing. We've captured the verbal part, and we've made a documentation of it because there's nothing to document that we verbally warned, right? Because it's verbal. So we have now captured the verbal in a document right here. Here it is in the termination letter. You can do the same in a write-up short of termination, where you say, we've talked to you on such and such date, or we verbally warned you in the past about this behavior. This is your first write-up, right? So we're capturing the previous verbals. Then we're going in the next paragraph. Through our counseling and detailing of our performance and expectations in the workplace for you, we have tried to work with you, i.e., we're out here trying, you're not, to resolve the problem. It is a problem. Despite our considerable efforts, because we're awesome, you have continued to play video games and ignore our counseling on the matter. Specifically, you were observed this morning playing Fortnite in your cubicle. Boom, that's the triggering event. So even if this guy, Gamer Boy, had filed a work comp claim the day before, we're showing that there's been previous stuff out there prior to the work comp claim, just in my imaginary situation. And then boom, we have an intervening event showing that, again, you're playing Fortnite in the cubicle. We warned you that that you could be fired for it. And there you are performing Fortnite. Now, if you wouldn't have fired him for playing Fortnite on this time, then you better not have fired him for it now, just because now he's on work comp, because he made a work comp claim. But if this is your typical, if you had warned him that next time you would be fired, boom, here it is. This was the next time. Doesn't even matter. They just engaged in protected conduct the day before. You caught him playing Fortnite in his cubicle. Termination. We wish you well going forward. This is how you do a termination letter. You could revise this, and it would be similar to a warning or a last chance agreement. This notice of termination, this is only for Minnesota employers. Just as a heads up, if you're here in the wonderful state of Minnesota, that if the person asks for the truthful reasons for their termination, contact legal counsel. And then you have to respond with them, and then you have to give that to them within 10 days. So not all states have that. It's a unique thing in Minnesota, but just a heads up. It also means that they've probably got a lawyer looking at this, and they're going to ask for a copy of their personnel file as well. Just a general thing on references. My recommendation, even though a lot of states have these protections against employers from giving truthful reasons for the reason that the employee is not working for them, I generally recommend just name, rank, and serial number. It's the best practice. You never know what a supervisor or an HR person is going to say, down the line. So just best practice to just as a company, just give name, rank, and serial number. And then if you want to ask if you want to answer the question of whether or not you would rehire the person, that's fine. You can answer that question, but otherwise, confirm employment, confirm dates of employment, confirm final rate of pay, confirm title of job, and maybe location of the job if it's asked, and then that's it. Anything else beyond that, it's not worth taking the risk of getting into a defamation lawsuit with a former employee. Okay. That's it. This is a little severance waiver release type of thing. If any of you do get into severances and waiver and release agreements, can definitely do that as well. But it has to be in writing, and it's an entire legal document that should be written by lawyers. Thank you. Sorry, I went a minute, 2 minutes over today. I am looking forward to next month's webinar is going to be, I think it's religious discrimination in the workplace. It's a Festivus December webinar. So I really appreciate everybody's attention. And if you want to watch this, it has been recorded. So it will be up on our website. And you are welcome to do so anytime, the hrgenius.com. And I will talk to everybody in December. Thanks.